Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How we doing? Let's see. Today, I've got a video for you, which is actually pulled from a live stream I did the other day. As many of you know, I am live streaming the Karen Reed trial, so that is what's happening during the daytime. This stream was a rare nighttime stream. We did not have court that day, so I fired up a stream, and part of it was to cover this oral argument by Courtney Clenney's lawyer and the state's attorney. And the question at bar for this case is whether or not the state's attorney's office that is handling the case should be removed from the case entirely due to allegations of misconduct. If you ask me, I say yes, because screw the government. I want it to be as absolutely difficult as possible for them to prosecute people and take away their life. That being said, they need to follow the rules to the T, and it appears that someone in this case did not do that. A detective Quinnen or attorney Quinnen, I don't really know. It doesn't matter. His name starts with a Q, ends with an N, and I don't care who he is. What he did, though, was receive privileged materials. He did not disclose the receipt of these privileged materials, and he proceeded to use those privileged materials to work on the case, and in fact, to, I believe, refer Courtney Clenney's parents for arrest based on communications that were supposed to be protected and between, client and counsel. That being said, he has since been screened from the case. However, Courtney Clenney's attorneys are saying not good enough. And under Florida law, they believe they are entitled to have the entire prosecutor's office removed. There's just one problem standing in the way, and that is the standard, which is what they're arguing over here. Now, we're going to go ahead and put up the first page of their motion, which should be sufficient to get into the argument. The only reason I'm talking so much right now, because you can just watch the whole thing in just a minute, with me giving commentary as I was watching it the first time, is that most of the way through it, I frustratingly realized that there's something wrong. There's something very, very wrong with this video and these lawyers. They were missing the point. They were missing the critical legal argument on both sides. And it was really, really infuriating. And I didn't know, of course, for sure, because I'm not a Florida lawyer and I had not researched this issue specifically or even come across it until this moment. Something was amiss the entire time, and I will tell you what it is, and I will tell you how they missed it. It remains amiss forever. And I checked their written briefing to see if they actually made the appropriate argument in the written briefing, and they did not, as far as I can tell, make the appropriate argument. Cannot speak the appropriate argument in their briefing. And it's a really frustrating thing to see both sides floundering and flopping on the issue. And the issue is staring you right in the face. Again, I am not a Florida attorney. However, just based on how this citation is written, how it's presented in paper form, how they attempted to argue it, all of that combines to, how do I word this? All of that combines to bring you to the conclusion that they done fucked up because they missed it. And it's, let me just show it to you. That's the easiest way to do this. So the first thing we have here, make me big. There we go. This is the defendant's reply, the state's response in opposition to defendant's amended motion to disqualify. So we're down the filing rabbit hole here, but here's where we are stuck. And we are stuck right on this, this bit at the beginning. To disqualify the state's attorney's office. This is in the quoted area. This is quoting Downs v. Moore, which we'll get to in just a minute. But you can see here, to disqualify the state attorney's office, the defendant must show substantial misconduct or actual prejudice. Now, The word or is in there. It's obviously in there. It's very important because it's in there. And if it wasn't important, it wouldn't be in there. If it was supposed to be and, it would be and. If it was supposed to be anything else, it would be anything else. But the word is or. The state attorney will stand there and argue that or does not mean or means and. Actually, or means ignore the first part and it's just go to the second part, which is in quotes, which he finds to be very, very important. It's not important in the way that he argues, though. His argument is either idiotic or disingenuous. One of the two. Neither is good look for a state's attorney. However, he argues that actual prejudice, which is in quotes, is the thing that they go on to identify in the ensuing citations from the block quote in the text. This is a dumb argument that it is required because it is in quotes. Now, the problem I had was trying to figure out why actual prejudice does go on to get identified and substantial misconduct does not go on to get identified. And this is where the state attorney lands. And it's like, okay, well, that's an interesting question. Why is it that we do have actual prejudice and we have nothing on substantial misconduct? And the answer is pretty simple, because the quote from Farina versus State is actual prejudice. That's the quote. Now, Farina versus State also incorporates substantial misconduct. And consequently, Downs v. Moore does as well. Substantial misconduct is in there. And substantial misconduct is pretty obvious. The state is actually lying here, because if they go through their citations, they will find examples of substantial misconduct clearly listed out. However, they were mooted by the court reversing on other grounds, and they weren't necessary for the court to explore further. Also, substantial misconduct is fact and case specific. So you don't get to have a blanket assertion of what it is. We just know that it is misconduct by a prosecution that is substantial. So it's not a missed email or something like that. It's a missed email that contains privileged information that you're supposed to return back and say, I'm so sorry. I don't know how we got this, but I didn't review it. And we have cleansed our servers of that email. Please let us know if there's any reassurances we can give you beyond our, promise as attorneys and our ethical obligations under the rules. That should matter. But if it's just, some other errant email coming in and they miss it, and there's no useful information or privileged information in it, and they mishandle the email, or maybe they have some terse words that are slightly inappropriate for someone who is representing the state. Who knows? Those minor misconducts that don't have any impact on on a defendant aren't really that important, but substantial misconduct is. And it's very simple. We have substantial misconduct all the time. The court deals with it. But again, it's fact and case specific. So there's no blanket statement of what it is or isn't. What there is an or. There's an or right there. I don't know why the state attorney can stand there and just lie and say that or doesn't exist. Or is right there. So what we have is substantial misconduct or actual prejudice. And the simple answer is that the quotes are just that. The quotes are not special. The quotes are just indicating that there's an actual quote, and it's actual prejudice. That is quoted from Farina v. State, and then subsequently quoted in Downs v. Moore because of it. Substantial misconduct is not quoted in Farina v. State, but like I said, we actually do have the whatchamacallit? We actually have the we actually have definition for substantial misconduct. I'll show you. I should just show you. My brain turned off for a minute. Don't worry. You can maybe worry. Farina's fourth issue concerns both the guilt and penalty phase. This is from, again, this Farina v. State from 1996. Before Farina's trial, the state attorney asked the court clerk to assign the case to another division, where a particular judge was the only sitting judge. Although the request was contrary to an administrative order controlling the assignment of cases, the clerk granted the request. The defense then filed a motion to disqualify the state attorney's office. The trial court conducted an evidentiary hearing, but denied the defense motion because no prejudice to the defendant had been shown. So this is where we're getting into actual prejudice, right? While we do not condone the prosecutor's actions, we do not find that the trial court abused its discretion in declining to disqualify the state attorney's office. We have held that disqualification is proper only if specific prejudice can be demonstrated. State versus Clausel. Actual prejudice is something more than the mere presence of impropriety. Disqualification of a state attorney is appropriate only to prevent the accused from suffering prejudice that he otherwise would not bear. Based on the record before us, including the fact that the judge the state may have hoped would try the case did not preside, we cannot say that Farina suffered any actual prejudice. Now, the state would like to have you end it there, but no, if we move on, we find out what happens. This is where actual prejudice is laid out as a quote up here. Substantial misconduct is something that is hacked together and thus does not belong in quotation marks. As the second part of this issue, Farina identifies 3 acts of prosecutorial misconduct that occurred during the penalty phase. He claims that the prosecutor made improper argument in his opening statement during the penalty phase. The state sought to reenact the crime by using the surviving victims, oh my God, other state attorney employees, and props, including a .32 caliber pistol, a dagger, and rope, and the state called Van Ness's father to the stand to testify despite an order prohibiting the use of victim impact testimony. Our resolution of issue 2, see infra, renders this part of the issue moot. That's fine that it renders this part of the issue moot and the court doesn't have to go into there, but we do have examples of substantial misconduct. The only thing we don't have is a combination of the term substantial misconduct. We have prosecutorial misconduct, and then we have the implication that that misconduct must be substantial. The reason it is not in quotes is merely because there is not a quote for substantial misconduct in Farina. And subsequently, when Downs is quoting Farina directly, it cannot quote substantial misconduct. We know that there is prosecutorial misconduct, and the implication is that if it is substantial, it is sufficient. And that is why in Downs versus Moore, there is an or. And it really pisses me off that neither attorney figured this out. Like, this is obvious if you just read it. If you just read the citations and you look at the sentence structure in Downs, you should know that that's what happened. This is basic legal writing. And yet these two attorneys are standing there like morons in front of the judge saying, no, it's not about or, it's not about this, it's not about that. This is all it's about. This is all it's about. And it's really frustrating to me. But that being said, that's the most important part of this argument. These guys both fumble. They're terrible because they leave out this critical element from their own citations, and they can't get there. They cannot get to this idea because they just can't get to the concept that substantial misconduct exists all the way back in 1996 in this Farina versus State case. It's just not quoted directly because that phrase didn't exist there. That phrase is created in Downs v. Moore. And the next time it's quoted, it would be quoted with the entire quotation mark with internal quotations for the Farina versus State case on actual prejudice. This is basic legal writing, and it was staring them in the face, and they were too damn smart to just get down to basics and figure it out. But I wanted to share it with you. I wanted you guys to see what's going on in this case. Courtney Clenney is trying to get the entire prosecutor's office thrown out. That would be devastating for the state of Florida and their prosecution. It would kind of reset everything, and they don't want to do it. They're fighting against that. They're trying to say that the misconduct that they have endured already has been dealt with and will not happen again. Without further ado, let me go ahead and send you on your way to watching this clip from the live stream I did the other day. Make sure you remember that I am live streaming again. Please join me anytime you would like, anytime you're available, and anytime you see me on there. And say hi. Stick around for a while. Click like. And on this one, click like, click subscribe, click share. I'll be watching the Courtney Clenney trial. And as it develops, I would love to cover it if we are able to get some cameras on it. it is one that is highly on my list. Until then, we'll cover motion hearings and stuff like that when I find something interesting. All right, guys. Catch you later. Enjoy the rest of the show. Peace. Peace. I have this Courtney Clenney video. It's a courtroom argument where Courtney Clenney, that's the Onlyfans chick who stabbed her boyfriend to death, she's trying to get the entire state prosecutor's office, or that county prosecutor's office thrown off the case because of allegations of misconduct, substantial misconduct. And the state is there trying to argue, again, as the state always does, that what happened didn't happen. Like they're like, well, no, that's not what happened. They try and tell you why it definitely didn't happen in the way that the defense said. The defense is always like, this is what happened. Like, how are we here where the state can just walk up and be like, well, I mean, no. It's like, yes, fully yes. What are you talking about? This video is all about counsel. Counsel is making the argument before the judge. So let's do it.
So are we ready to go? We have defense counsel here, state here, defendant is present. You guys ready to go?
Yes, Judge. Sean Abuhoff on behalf of the state, along with Kathleen Hogue.
And Frank Rekieta on behalf of Ms. Clenney. She's present before the court, and also co-counsel Ms. Pugliese.
So we are here for defendant's motion or amended motion to disqualify the state attorney's office. I was able to get through a lot of the binder.
So this is cool. Also, just procedurally different than a lot of stuff that we've watched on my channel. That's not, I don't know what you guys have watched anywhere else, but this is one of the ones where, it's a defense motion. They get to actually start. Most of the time, doing the trial watch, we're watching the state's bringing the case, the state's bringing motions, and so they get to start the argument. In this case, the defense is starting the argument. I'm realizing in Karen Reed case, it happens a lot, but the arguments aren't as like, this is a specific motion hearing here, so it's not as formalized. In the Karen Reed case, like the arguments are happening there in the courtroom, in the midst of things. Like this is a separate and segregated hearing. There's no audience. The defendant's not there, etc.
The motions, the response, and some of the case law, but we're ready to go. So defense.
Yes, Judge. You have the binder. I know you've read it.
I haven't read through all of it.
Okay.
Got dropped off a day in advance, but I have
Sure.
read through a lot of it.
Sure. And Judge, our written pleadings say a lot. And so I don't think this oral argument
It sounds like every lawyer
repeat
ever.
everything that's already been
Our written
delineated in
say a
our
lot.
amended motion and especially in the reply. So I'm just going to highlight some things for you. So the standard is.
So for the standard and why you believe you've met the standard and.
Yeah, so the standard to disqualify the state attorney's office is found in Downs versus Moore. And that is the defendant must show substantial misconduct or actual prejudice. And the case law that interprets what actual.
So at the end of the day says, I want to see her parents' trial. Now this is crazy. This is related to that. So there were some communications between Courtney Clenney and her attorneys. Those communications ended up in the hands of the prosecutor's office. I don't know how. It doesn't really matter. Those are privileged and protected communications. The prosecutor's office used those protected communications to refer the parents of Courtney Clenney for arrest. So I don't know exactly what was stated in those privileged communications, but her parents were arrested. At the end of the day says, I want to see your parents' trial. Well, her parents' charges only exist because of the unlawful disclosure of these privileged documents. So that'll be a really interesting case too, that in my opinion should maybe be dismissed pre-trial because the information that they used to develop probable cause was improperly obtained. But see, the state kind of doesn't care about that sometimes.
Prejudice means it's more than just an appearance of impropriety. But in the reply, in the state's response to our motion, they're highlighting most of the conduct that they've done after what I would refer to as the misconduct of ASA claim. the court is intimately familiar with those facts. You said in the deposition, so I don't need to rehash the facts of that particular breach into the defense camp. What the state argues is that, look at everything that we've done since. We've sealed the V case off, we've restricted access. I would just note that Mr. Quinn's still on the delivery list for pleadings, but we unclick him.
Okay, so Mr. Quinlan, whatever, I don't know his full name, it doesn't matter. He was the officer who observed the materials. Now, this other smug asshole, who's the state prosecutor, is going to claim that he's been sealed off effectively from the prosecutor's office, and he will not have access to any of this case information. He won't be able to transmit case information. This is crazy and stupid and a lie every single time. This is the state saying that the state employees who work next to all the other state employees are sealed off from a case, even though they can literally just walk next door and talk about the case and deliver information and provide updates or whatever. But they're like, no, we have the ample ability to go ahead and do this. But they could just, they're at the office, they're in the lunchroom talking, etc. This should not be allowed. There's impropriety that has happened. They need to go. That's how it should be. It's not how it is, but it's how it should be. The rule is to disqualify the state attorney's office. A defendant must show substantial misconduct or actual prejudice. The state is going to focus, the defense is talking right now, except for I'm interrupting him. I'm very sorry, sir. Not really. The state is going to talk about how this actual prejudice is all that matters. The substantial misconduct isn't what matters, because the argument or the idea is that the substantial misconduct doesn't affect the defendant, then it doesn't really matter. But the idea that the substantial misconduct is able to even occur because the state, the state attorneys are engaging in misconduct now, lends to the idea that the state attorneys will also similarly engage in misconduct later. That misconduct may not be caught and may actually prejudice the defendant, but you don't need it to prejudice the defendant. The rule is substantial misconduct or actual prejudice. So we are going to have a state attorney infuriatingly sit here and tell us how or doesn't mean or. Yes, that's actually coming. If I can ever let us get there.
What I think is most important, Judge, is Mr. Abahoff and Ms. Hogue. It's not what they did, Judge. It's what they didn't do. As soon as we realized upon the arrest of Courtney Clenney's parents and the allegations contained within the arrest warrant, it was clear that the state had obtained our work product or attorney-client privileged communications.
Yep.
As recommended by the Florida Bar.
Throw them out.
As soon as we realized that they weren't in possession of our confidential communications, we sent a letter addressed to Chief Assistant Kathleen Hogue, Sean Abahoff, and Mr. Quinnen. That first letter was February 15th of 2023. The response we received from the state was complete silence. They didn't even acknowledge receiving this. Another letter shortly thereafter, February 28th.
The state has these documents and they just pretend that
same
they
letter, second request.
What do we do? What are you talking about?
That was received,
We're not going to
sent
answer
out
this.
via email. And the response to that request for having our confidential privileged documents back or communications was silence. Third request, this one came February 10 of 2025. That was after the chapter 119 revealed the email, the confidential privileged email. We sent the third request again. Ms. Hogue, Mr. Abahoff, Mr. Quinnen. This third request for our work product and confidential communications again met with silence. The case law that we've talked about in the written submissions talks about substantial misconduct. And what does that mean? The case law doesn't say exactly what that means, but what the case law does say, every case needs to be looked at on a case-by-case basis.
Right.
So we have to look at the facts of what has occurred in this litigation, and the appellate courts again would review that.
So the state will sit and argue that there was no substantial misconduct because nothing bad happened. You know, we've now segregated off the thing. None of us have viewed the privileged materials, et cetera. But arresting the defendant's parents, that's a flex, right? Like that's a flex. And they did it improperly. They illegally obtained the information required to generate the probable cause for the arrest. And we can infer that they did that because they didn't do the arrest until after they got the information. Prior to that, they weren't able to do it. And they, as he basically said, based on what the complaint was, we could tell that they had this private conversation or the private information that they shouldn't have, our attorney-client privileged communications. And so, but what is that? Is that substantial misconduct? Is that prejudicial? I don't know. Are you more likely to have a plea deal if your parents are arrested because of you? Are you maybe get them out of trouble so you do the thing for your, like you take the blame or something? Like there's all sorts of pressures that could be levied, even though it doesn't have a direct and specific impact on this particular person. In some ways it has, but it also has direct but intangible impacts in others. So it's crazy that the state will do this, and they'll do this with a straight face. They'll just say, yeah, nothing bad happened. What are we talking about?
On a case-by-case basis, because every misconduct is, it would, I think, be different. So what we have here is, again, the court's very aware of Mr. Quinnen's misconduct, but Mr. Abuhoff and Ms. Hogue, they had a responsibility. When they received these letters, they should have said, you know what, Frank, Sabrina, let's look into this. What exactly is it that you think that we have? They didn't do anything. So I believe their misconduct is by omission, which I think the court should consider in combination with the misconduct of ASA Quinnen in reviewing those materials, not disclosing that to the court, which is it's not a two-prong analysis. It's substantial misconduct or it's not and what the state relies on is the actual prejudice. They're saying, hey, she hasn't been prejudiced. Nobody else has seen this stuff. But I think the analysis that we think is important for the court to consider is, does the conduct of the state by acts or omissions rise to the level of substantial misconduct? And I think it has. They had an opportunity to do the right thing when they received our correspondence. Hey, let me investigate this. What are they talking about? Let's talk to Quinnen and figure this out. Because if there was something done that was improper, they could have nipped it in the bud right there. And they didn't. So I think it's the combination again, the acts and then the omissions on the part of the state. And I think it rises to the level of substantial misconduct. The appellate court decision.
Of course it does. There's no question that in any logical mind, in any normal, rational person, you go and you say, so police illegally obtained privileged communications from one person to another, and then they use those communications to arrest their parents. Is that substantial misconduct? Yes. Every time. Anyone who says no is wrong. I'm sorry. There's just no way around it. In a logical and just world, that is substantial misconduct without a single ounce of hesitation.
One that the state talks about is Nunez. We think this case is more similar to that of Martinez versus state, where ASAs heard jail calls between the attorney and the client. And in that case, in the Martinez case, the third district, I think it was the third district case.
Is the government out to get citizens? Yes.
Fourth. In that particular case, that was affirmed on appeal. So it really is very unique circumstances that we're in. I haven't litigated a case of motion either on the side of the state or defense now 25 years. So it's an interesting topic. But I think that what occurred here, Judge, it's an abuse of discretion standard. I think there's substantial record evidence of what occurred and what should have occurred or didn't occur that would support, Your Honor, disqualifying the entire office. And
again, so basically, like there is actually a rule book on what to happen, what should happen when privileged materials are sent to the wrong party. There's an actual rule book to follow, and the state didn't do it.
That's what the defense is asking. The entire Miami-Dade State Attorney's Office should be disqualified.
Right, state.
Yes, Judge. So it's the state's position that the defense is misinterpreting the law on this issue. The defense
Okay.
wants to separate substantial misconduct or actual prejudice. But I think the case law is very clear, and there's a reason why quotations only appear around actual prejudice after.
No, there's a word that matters. It's or. Or is the word or. The or is not and. Or is never and. Or is always or. And isn't or. And or isn't and. The word is or.
After the term substantial misconduct. And I think that's meant to define. There's a reason why in all of this, the case law.
Oh my gosh. So this is quoting Downs v. Moore, which is the controlling case on this issue. To disqualify the state attorney's office, a defendant must show substantial misconduct or, in quotes, actual prejudice. The reason they put it in quotes is because they're delineating it as a specific term of art, that there's some sort of definition that they are probably going to give us, maybe a test, or no. What am I talking about? They're saying actual prejudice. It's in quotes just because it's from Farina versus State. I'm going way too far. It's just simply a direct quote from this case. So again, the operative word here is or. It's this one or this one. So holding actual prejudice not shown where state attorney improperly asked clerk's office to assign case to a particular division. Receded from other grounds, blah, 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 blah. Actual prejudice is something more than the mere appearance of impropriety, which doesn't matter that that's the definition of it, because we also have substantial misconduct. Now, substantial misconduct may not be defined already, but there's plenty of room to step in on that one. So anyway, this just pisses me off because here it is. Like, this is the standard: substantial misconduct or actual prejudice. And you have a state attorney right now, unironically and without a hint of hesitation, saying, no, the or doesn't mean or.
Law on this issue, it only goes on to elaborate on this actual prejudice and what it is, and not just a mere appearance of impropriety.
So that
So
doesn't
that's
matter.
the major part here. And if you look at all the cases that even the defense cites to, they all come about by some form of misconduct by the state. And the question just comes, does it rise to the level of substantial misconduct? And the analysis all comes down to, is there actual prejudice by the defendant at the time? And is there a fear of potential future risk of prejudice?
Right. That's the
So I think that's the analysis. And I think the
first
defense,
path is just
certainly wants
misconduct.
to look at this individually and point to just substantial misconduct without a definition, whereas all the case law gives.
This guy, do you hear this? Look, he wants to look at this individually with just substantial misconduct, whereas all the case law is about this. So what all the case law says, like, the court has the ability to figure out what substantial misconduct means. It's misconduct that is substantial. That's what that happened. That unequivocally happened in this case.
Gives it to us. And when you look at those cases, there are plenty of them that are similar to this. You look at McWaters v. State, that the defense side of the Florida Supreme Court 2010. That's where the state actually even listened to jail calls between the attorneys and their client. So there's some form of misconduct that far exceeds what this can even be, but that's part of this analysis. And we have to look to and break down both who are the actors, and what is the prejudice that the defendant faces. And the question here is, does the defendant face prejudice right now in the position that she's in, with Ms. Hogan, myself remaining on the case? And then if that is actually true, then the question would then move to the office as a whole. So I can take, and I would argue, Your Honor, that she does not face any prejudice, and we can break down the two breaches that Your Honor has found to be breaches. The first being
Your Honor, the judge has already found breaches. He's saying, like, I don't know. I've not followed the rulings on these cases, so I apologize. Like, this was sent to me today, and I found it was really interesting when I watched it earlier. The judge has apparently already found that there is misconduct that has occurred. So I guess she just has to determine if it's substantial or not. But again, the or makes it so that it's one or the other. You don't have to have both. This guy's like, it's got to be both. It just has to be. No, it doesn't.
Text communications. Defense points to these letters that they've sent to us, the February 15th and February 28th, 2023 letters that were received with silence. That's because after this all came about, we had all of this litigation on the issues of whether or not it was protected material on that computer case, that access case. Your Honor took control of those drives and it's been in your possession ever since. So the idea of being able to turn back over these items, they were not in our possession. So I don't think we can be faulted for not responding to their letters. The content of those letters are important though. And that's why McWaters becomes an important case, because in that case, in denying the motion for sanctions or disqualification, the court found that there's no evidence that the substance of these calls provided any benefit to the prosecution or were used in a way that detrimented the defendant. So McWaters goes on to explain that when you look at the context of those communications, there was no detriment to the defendant at that time or any future.
But there is a detriment to Courtney Clenney having her parents arrested. You have substantial, again, you have a prejudicial impact there because the arrest of her parents could make her decisions different in how she pursues her case strategy. She maybe she hates her parents. It doesn't matter either way. If the arrest of those parents may have information that would help a prosecution. And so a plea deal with those parents that involves the exchange of information enrolling on their daughter might be quite prejudicial against her. I guess this is unreal that the state will stand there and say that there's no prejudicial impact. There's nothing there. I mean, just the intangible impact on how you think about your own case, knowing that the state looked at your privileged communication, arrested your parents from it, is like it's unfathomable.
Risk because the calls were what they were. These communications, the only person who reviewed them was Mr. Quinn in their original format. The world has had an opportunity to review them in the arrest warrant and in the search warrants. And what is clear is that those are just discussing the access of the computers. So there's no prejudicial information within those text messages that either myself or Ms. Hogue have seen, or really anybody in the world has seen. And through Mr. Quinn's deposition, he did not even see. It was limited to just that. So from the context of just the communications of those text messages, there's no work product, or I should say no defense theory of the case. There's no strategy concerning the homicide prosecution itself. It merely is the access of this computer. That being said, again, myself and Ms. Hogue did not access this. So as we sit here today, there is no actual prejudice that the defendant faces. It cannot, I don't even believe it rises to the level of an appearance of impropriety, but that, even if it did, that is not enough. But I think the analysis really, and the harder question here is now moving to that, and I termed it in my motion, the Puglisi email. What's clear is that no one that is currently on the state's prosecution team had an opportunity to review this. Mr. Quinn himself did not remember this item, because when Your Honor ordered every part of the communications turned over to you,
completely forgotten.
This would have been included. This is part of that. This doesn't come about until there is a public record request. And that is when the defense sends us, once they're made aware of it, they send us a letter to have us turn it over. Again, it's met with silence because we don't need to respond to it, but we do take action in it. And that's the importance. Myself, Ms. Hogue has come before this court and stated that we have not viewed it.
We didn't look at it.
And we don't plan to view it. And I don't believe anybody in our office could ever view it, because I've been able to verify it has been deleted from our servers. So
we're going to talk about it with
the
someone
only
who did
person
view it.
who accessed this is Mr. Quinn. And in his deposition, what was clear from that was the only thing that he remembered from it was the name Mr. Haas, which was their computer expert. And again, going towards that investigation, that separate matter. So when you look at that, that is the Nunez case very specifically. It is a person who accessed, an individual who accessed attorney-client information and the contents, and we have no problem with stipulating that the contents would be prejudicial if the state reviewed it. Mr. Quinnen does not remember the contents of it. His only knowledge.
So they are willing to say, yeah, we know that it would be prejudicial if the state reviewed that. But he didn't remember. We have to help him with Campbell's soup. I mean, he doesn't trust me. He doesn't remember. There's no way he would talk to these guys about anything that's in there.
Based on the deposition is the Mr. Haas aspect of it. And so he's also stated in that deposition, we've affirmed he has not discussed with anybody in the state attorney's office the contents of that document. So that goes to the Nunez case, which in that case they found, based on what the court deemed as misconduct, did not rise to the level of substantial misconduct for the office. It did for that prosecutor. They removed that prosecutor, but not the office. So that's why this is not State v. Martinez. In that instance, that prosecutor, not only that prosecutor, other prosecutors heard the calls and were discussing throughout the office. The state has done its proactive work to ensure that the rights of the defendant aren't violated, that the defense team's communications aren't overheard, and we have a filter protocol in place for all of this. Your Honor has been made aware that once and if Your Honor rules to not disqualify us, we have someone coming to receive these drives to ensure that that is all filtered out. We have no issue with allowing the defense to review those drives prior to any of the prosecution team, or certainly the court, if Your Honor wants to review them. We have no issue with doing that, and I think that's the appropriate thing now that we're here where we are. So we can ensure that there's no more of those text communications that can be reviewed. Concerning this document itself, again, it's been wiped from our servers. No one can access it, and I've been able to verify that. So that's why this does not go to the State v. Martinez case, and this is the Nunez case. Bless you. The other part is that Mr. Quinnen has been screened off the case, and that's why I created the analogy of this is different from the Popjoy case, which is a third DCA case from 1992. That case, the office that was taken off of the case, too small to be able to handle that situation. And so the dissemination of information was inevitable. That's not what this is. The Miami-Dade State Attorney's Office is one of the largest in the country, one of the largest in the state of Florida, possibly the largest in the state of Florida. We were able to screen Mr. Quinnen to where he doesn't have access to the electronic file. He doesn't have access to the hard file.
Give it to a different
He doesn't have access to myself or Ms. Hogue. And actually his office is on the far reaches of the state attorney's office to where we don't have to interact with him. So we're able to ensure that anything that he has seen, which the deposition shows that there really isn't any prejudicial information, would not come about or would be discussed with the current prosecution team. So that screening process is an important part and why there is no risk of future prejudice that the defendant might face. So, Your Honor, based on the arguments that I'm making, as the defendant sits here now.
Screening is the real thing that law firms do, and law firms include, state and county attorney's offices. That is something that happens because especially in bigger law firms, you would have firms that represent clients at different points in their lives that would be conflicts of interest if you went by and all of the ethical rules. And so you're going to run into conflicts, but one way to do that is just screen people off. But this isn't this isn't a civil case about, the borderline of two plots of land. This is a woman who's charged with murder and could go to prison for a really long time, if not forever. So, it kind of matters. I don't think screening is sufficient. I think there's a rule that says substantial misconduct means you go. He's like, well, we're one of the biggest law offices in the state or whatever. Great, cool. Use a different one. Fuck off.
Now, based on what Your Honor has deemed breaches, two separate breaches, or one separate breach, but two separate items, there is no actual prejudice as she sits here now with the current prosecution team, let alone the office itself. And then the risk of any future potential breaches or prejudice, we believe that we've taken proactive measures to ensure that that will not be a concern for this court or the defense team.
Your Honor, it's the credibility of the testimony by Mr. Quinnen that he just forgot right? He forgot discovering the linchpin, the evidence that he needed to find the laptop, locate our expert. That is just that Your Honor can evaluate the credibility of those statements.
Yeah, they're obviously false. They're always
What the state is trying,
yeah,
just
state attorneys are all
let's
just
talk more
dumb
about
when they
what-
need to
what
be.
occurred.
But only when
Mr.
they need to be.
Quinney
These are smart
disseminated
people,
that information to law enforcement.
particularly in regards to data recall and
His
stuff
testimony
like that.
was
Like,
he didn't
they remember
disseminate it
details.
to anybody else in the office. We know that the copy of that email was on the servers, but I do believe, and I do not doubt Ms. Hogue and Mr. Abhoff's representations to the court that they did not view it. But going back, the state's arguing that it's substantial misconduct has to have actual prejudice, but it's an or. And the quotes, I would say, are because the Downs versus Moore doesn't say prejudice. It says actual prejudice. That's the distinction of the quotes. It's an or situation. So for that substantial misconduct,
So I think you
we
fell
have to
into a
look
trap
at
there because
what
he was arguing the same thing I
conduct of
was.
Mr. Quinnen.
I'm like, why are there
And then
quotes
again,
here?
the
Well, the quotes are
omissions, I
just
believe,
simple
on the
because
part of
it's
the
cited in the next
prosecutors.
thing. The words are taken from that and then put into Downs v.
The-
Moore.
In the case of Nespler, which I think the state and the defense have,
I'm really mad, actually. No, let's go back to this. This is really important. This is okay. The reason that actual prejudice has a quote here is because that's the prior standard in Farina versus State, which is now being cited in Downs v. Moore. But Downs v. Moore, they add substantial misconduct. So they're actually changing the standard and adding a second prong, and that should be where they focus their argument. Damn it. Why did I miss this earlier? This should have been Courtney Clenney's team's argument is, no, Your Honor. In fact, actual prejudice is in quotes because there's a strong history of protecting defendants from actual prejudice. But the court in Downs v. Moore found it not sufficient. So they added a second prong, or substantial misconduct or actual prejudice. That's why there's also no subsequent definition. This is a new phrase that's coming into that case. That should have been the argument. That substantial misconduct is the addition to the existing line of legal reasoning, and the or is obviously added intentionally to delineate these two things. They needed an alternative approach because that actual prejudice was probably too high of a standard in some cases, even though there was misconduct, and the misconduct is enough that that the prejudice doesn't matter because it means that there's likely more misconduct on the way. That's the argument they should have made. Now I'm really pissed off.
have argued in our written pleadings. I guess that's the beauty of the law. We're almost citing the exact same cases, but interpreting them differently. And then Your Honor has to figure out that who's wrong and who's right in a somewhat of a gray area. But Nespler, that's spelled with a K-N. ESPLER versus State 314 Southern 3rd 287. That's a 3rd district case. And they cite to one of kind of the staple Supreme Court cases that addresses this issue, which is State versus Fitzpatrick 464 SO2D 1185, Florida 1985. So they talk about how the state is different than a law office. And they say there's a distinction between private law firms and government prosecutorial offices, and that's citing State versus Fitzpatrick. So as a result of that distinction, the Florida Supreme Court has recited that imputed disqualification of the entire attorney's office is unnecessary, meaning
I've
you can't
never
do
been
it,
able to,
or you shouldn't do it, when the record establishes that the disqualified attorney, who I would say here is Mr. Quinnen, right, has neither one, provided prejudicial information relating to the pending criminal charge, which I think that's a tough sell, nor meaning, and he also has not personally assisted in any capacity in the prosecution of the charge. Mr. Quinnen clearly, right, personally assisted in a whole bunch of capacities, right, in the prosecution of the charge. And again, that's, so why is disqualification of the entire office appropriate? Because he, Mr. Quinnen, personally assisted in any capacity in the prosecution of the charge. And that's at 1188 in the Fitzpatrick case. So, you know, we always, when I was in county court and we were all, you know, in county court, the judges, when it's DUI Mondays, there's the state, oh, judge, this isn't my case. This is, I say, so where's he? He's in the hallway, right? Well, you are fungible. That's what we used to always get. Well, you're fungible. You can go ahead and try this case, Mr. Prieto. So it's that distinction. The state is kind of considered their one fungible body. And that's what Fitzpatrick talks about, is that if I believe it stands for the proposition that if the attorney that was disqualified participated in the case, that's it. You can do it. Right? So I think if you look at you know, the totality of the circumstances of the misconduct by act or omission, I think that your honor would be on solid ground in the third if you disqualify the entire office.
Yeah, of course. Of course, she would be on solid ground. It follows the exact standard of what's in the ruling, but that, you know, as we all know, doesn't really matter.
Judge, if I could just clarification, no argument. For the disseminated to law enforcement, that Mr. Quinnen, that was only specifically those law enforcement officers were on the computer case, is my understanding. And if defense knows otherwise, I believe it's just the.
I believe that's correct. Yes,
right. So that's a different department than prosecuting the homicide.
I mean, insane. Again, well, look, it was only these law enforcement that it's not the homicide. And that's what they do. Yeah, it's not the homicide where the prejudice is occurring. You've segregated that off. It's so great. It's just this other case that now exists that has a direct tie to her personally. And that direct tie could influence the decision-making she has in levying a proper and competent defense. Like this.
So I think that is also important to note, because that's also other screening that can take place, that there has not been discussions with those officers, as that case no longer exists. And the only other part would be that the Nespler case is a third DCA case that comes after the Nunez case, and Nespler does not discuss the Nunez case or call into question the Nunez ruling.
Judge, I do appreciate the state has tucked away Mr. Quinnen in the far reaches of the office. But you know,
He was stuck there before.
yeah, well, you know, we have to rely that he's not going to speak to anybody. And I think that that's the fear that the client.
There it is. We have to rely that he's not going to speak to anybody. He's not going to suddenly have a memory issue where he remembers everything that he just forgotten. And now he's going to just go ahead and talk like all the time to everybody who could listen. But not the people on the case, though. He wouldn't talk to them, right? Like he's screened off. So maybe he'll talk to someone else. And then that'll get back somehow. It happens all the time.
We have as a defense team that there's nothing to stop the state from, well, we'll end it there, Judge. I appreciate the court's time and the hearing, and
Right.
appreciate the state's arguments.
Okay, so there's nothing else to watch on that one. She just goes on to say that she has to review the file. Thank you for the arguments. I think no, but Clenney's team, I think, missed I haven't read their motion, so maybe they get into that argument. But I think just revisiting it real quick. This is it. The actual prejudice is quoted in Farina versus State, 1996. The substantial misconduct, I'm guessing, is added in Downs v. Moore. Like that is new from the court, and that or matters. Maybe I'm completely wrong. I don't know. I'd be very surprised. I think that might be the mystery as to why we have a quote here, because it's like, oh, well, we already have this line, but we don't have this one. So what's the difference? What did the ruling change? What made it different from this existing standard? Because the state here just basically argues that the existing standard in Farina versus State that is citing with the actual prejudice was sufficient. The Downs v. Moore is not necessary, even though it adds a clause to substantial conduct or actual prejudice. By adding that in, that doesn't matter. That shouldn't have happened. That's the state's argument. It's a bad argument, but I don't know that Clenney's team capitalized it. I'll probably go through this Courtney Clenney thing on my own and see if it's worth reading on stream.